We're on Unit 2, Part 4 of the study guide. So what is a pardon? Does it mean to commute a sentence? And why do presidents use these powers carefully? So when you pardon someone, you excuse and you forgive the person for the crime. So they remove it actually from your record. When you commute someone's sentence, you shorten it, but you don't necessarily forgive them for the crime. So, like I show you right here is Gerald Ford, President Ford pardoning Nixon. And he gave Nixon a pardon for any involvement he might have had in the Watergate scandal. So a pardon completely excuses, it erases the crime. Commuting, you get a shortened sentence, but you don't get forgiven. So anytime a president actually uses this, they have to explain to the American people why they've done it. Like if you're commuting someone who has a horrible crime record, you got to tell the American people why you're actually doing that, and voters will hold you accountable for it. Governors also have the power of pardon because governors are like a president, but they're in the state, so they're the head executive of a state. Number 34 is, what does the writ of habeas corpus and the bill of attainder guarantee American citizens? That if you're accused of a crime, you will have a fair trial and a just trial in the U.S. So it doesn't matter like what is going on. Technically, you're supposed to be brought to a court, heard the actual like charges against you, and have a quick, speedy trial. Now, there has been times when the writ of habeas corpus has been suspended, like during the Civil War with President Lincoln. So he actually did suspend it during the war years. Question 35 is, why are congresspersons protected while serving in Congress? Simply to get you and I the best bills and best laws possible. So they're supposed to be able to exercise their freedom of speech during the time that they are representing us in Congress. So if they want to criticize the president's plan, they're allowed to, because they shouldn't be afraid to say something that they're going to get arrested for because they don't agree with the president. So to ensure true will of the people, they can say what they want. With all like freedom of speech stuff, there are limits. Like they cannot make a direct threat against a person. Okay, so they're not allowed to threaten bodily harm, physical harm to another person. So there's always, those little like catches on freedom of speech. Okay. So the next question, 36, is, for the following, identify the court cases described, and then you had to identify the amendment. So we went over this, like all these, for 2 days. So Bach versus the region of the University of California at Berkeley. He is arguing about reverse discrimination. So he is saying because he's a white student, he was denied admission because of his race. The university actually admitted that is why they denied him. And so the Supreme Court said you can't use race to discriminate against anyone. And that was a 14th Amendment Equal Protection Clause. Brown versus Board of Education of Topeka, Kansas is another 14th Amendment Equal Protection Clause. So at this time period, there was segregation in the nation. You had schools for white children and schools for black children. And what the Supreme Court ruled was that separate schools can't be equal. When you start separating kids based on race, you're actually making it unequal. And so it overturned, it threw out that old Plessy versus Ferguson ruling that said separate but equal. Marbury versus Madison doesn't have an amendment issue, but Marbury versus Madison allows the Brown ruling to ever occur because it establishes judicial review. The court can go back and review previous cases and laws to determine whether they're legal or illegal, whether they're constitutional or unconstitutional. So in Korematsu versus the U.S., the actual Supreme Court hears a case about Japanese American internment camps. And in this court case, they actually agree that internment camps are legal during war. Now, later in the 80s, the U.S. government's going to officially apologize for housing Japanese Americans against their will at these internment camps. And Fred Korematsu, had sued under the Fifth Amendment due process. He said because he's being held against his will, he should have a trial. The Supreme Court didn't rule that then, but they would rule that way today. They would rule that if you're being held, you have the right to have a trial. So Johnson versus Texas is the flag burning case, and this is about freedom of speech, so First Amendment. So yes, you can burn the U.S. flag. It is protected under freedom of speech. So his conviction got overturned. It meant it got thrown out. The next court case is Mapp versus Ohio. So Mapp, the cops had thrown up a fake search warrant. They searched her house. They found things. They charged her, and they went forward with a trial, and she was found guilty. And she argued, and the Supreme Court agreed, that because all the evidence was collected under a fake or illegal search warrant, they couldn't use it in a court of law against her. So her conviction gets thrown out. But this is the Fourth Amendment search and seizure. The government cannot search your private residence without just cause. Like, there has to be a search warrant. They have to actually tell the judge why they want a search warrant issued. So there has to be reason why they need to come on your premises and look at things. And then they have to present it to you, and you let them in, okay? Now, Miranda versus Arizona is a Fifth Amendment self-incrimination. So Miranda is admitting to raping and kidnapping females in the area, and he was never read his rights. He didn't know he could just be quiet. He didn't have to say anything. So as a result of the Miranda ruling, we now have the Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. They're informing you of your right of no self-incrimination. You don't have to talk. The next court case we look at is Swan versus Charlotte Mecklenburg Board of Education, North Carolina. So in Swan, some of the children are being bused from one end to the next. So you have children who are being bused 2 hours away from their home. Charlotte's a huge city. So the reason why the school system is doing it is to force integration. So they're trying to integrate the public school system. Parents complained, they sued, and what the Supreme Court said is, if busing is what you have to do to integrate schools to make them actually racially diverse, then that's what you have to do. And so you still see, like in Raleigh, where they bus kids on a regular basis. So like there are every year, there's always some parent complaining, but technically Wake County is doing what they're legally supposed to do. They're integrating the public school system. The next part of those is Tinker versus Des Moines. So the First Amendment, freedom of speech. The students were wearing those armbands to protest the war in Vietnam, and they didn't interrupt the educational day. They walked in the class with armbands on. They're not like doing verbal protesting. They're not, like fussing out their teachers. They're not doing anything like that. All they're doing is wearing the armbands. And so they got suspended. They sue all the way up to the Supreme Court, so they appeal their case all the way up to the Supreme Court, and the Supreme Court agrees with the kids. Speech is not limited to just verbal spoken words. It can also be unspoken. Also, because the kids aren't interrupting the flow of the educational day, technically they're not doing anything where the Supreme Court is going to say they're hurting the education of other kids. Now, if they were hurting the education of other kids, it wouldn't have been allowed. So Frazier versus Bethel School District. Frazier's the student who gives a very lewd, risky speech. So he gives a speech that has a lot of hidden meaning in it. And he was advised not to give the speech. He gets suspended. He appeals his suspension all the way up to the Supreme Court. When the Supreme Court heard the case, they actually agreed with the school system. They said because you have a freedom of speech issue, if it interrupts the flow of the educational day, the environment, then you're technically allowed to suspend them. So we can restrict freedom of speech if it interrupts the flow of the educational day. So his suspension held. Plessy versus Ferguson is that 14th Amendment case, and that was in 1896. Plessy is 1/8 African American. He sits in a white-only section of a railroad car, and he's arrested. When the Supreme Court hears the case, they actually ruled that his 14th Amendment is not being violated. They said because there's a train car for white people, there's a train car for everybody else. So that's equal in number. So Plessy's conviction was held, it was upheld, and he paid his fine and he did his time. Okay. Later, this court case will be reviewed with Brown and it will be thrown out. And so what Plessy's really its lasting legacy is it legalized segregation. It said segregation was okay because if you have one, you must have the other one. And it only meant, remember, equal in number. It's not equal in quality. Because when you looked at the different stuff, there is no way that that is equal. Hazelwood versus Krollmeyer is the First Amendment freedom of press, freedom of speech kind of thing. So in this court case, the girl sues because the principal has he has censored her newspaper articles. And the articles were on divorce and abortion, and she wanted it to run in the school newspaper. What the Supreme Court ruled is because the newspaper carried the school's name, they're allowed to edit, they're allowed to say no to pieces being presented in it. So freedom of press can be limited in a public school system because it carries the name. Engel versus Vitale is the First Amendment freedom of religion case. So the kids in New York are being forced to recite the Lord's Prayer every single day. And some of the parents have a problem with it. They've asked the school to stop. The school's not going to stop. And so they take their case all the way up to the Supreme Court. When the Supreme Court hears it, they agree with the parents. When the school, which is a state government institution, is reading a prayer, they have chosen a religion, and the government is not allowed to choose a religion. This is part of that establishment. The government cannot establish a religion. So no more prayer in school. Students can pray all they want. Students can initiate prayer, but a state employee cannot. So a teacher, a principal, they're not allowed to. McCulloch versus Maryland is the bank, okay? So Maryland tries to tax the U.S. government who had a bank in the state of Maryland. When the Supreme Court heard the case, they're like, nope, federal government is supreme. States cannot tax the federal government. So a state cannot tax a federal institution because the federal government is supreme. Think about it like with Fort Bragg. When you go on Fort Bragg and you shop at the commissary or you shop at the PX, those are government owned and you don't pay a tax to the state of North Carolina there. There's a usage fee, but it's not a sales tax to North Carolina. TLO versus New Jersey is the search and seizure. So TLO, she comes out of the bathroom, there's smoke, it's marijuana. They find her, they have her turn up her purse, turn out her purse. So when her purse is open, they find a stack of money, rolling papers, and a list of her clients' names. So they charge her with drug dealing. She appeals her case all the way up to the Supreme Court because she says that they didn't have a search warrant to search her personal property, her purse. The Supreme Court said, no, if schools have reasonable suspicion, they can search what's on their premises. And that's about keeping safety and security of minors. Okay, so to keep the educational flow of the day and to keep the safety of the kids, yes, schools can do reasonable suspicion searches. Gideon versus Wainwright. Yeah, the guy is accused of breaking into a pool hall, and he's got he's had priors on his record, so they charge him with a felony breaking and entering. He asked the Florida judge for a lawyer. He says, I can't afford a lawyer. Could you please appoint one to me? And the judge said no, because the prison charge was not going to be very long. It was only going to be a couple of years, right? So he doesn't get a lawyer. He gets convicted, and he appeals his case up to the Supreme Court. The Supreme Court agreed with Gideon. They said, because you're being accused of a felony, which means prison time, more than 1 year, the state has to provide you with an attorney, a lawyer. Gregg versus Georgia is where they reinstate the death penalty. Gregg is the one who had, a crime spree through North Carolina, South Carolina, and Georgia, and he has committed multiple murders. And because we had a previous case of Furman, Gregg's capital punishment is upheld.